I'd like to introduce Professor Mara Kolesas, and Professor Kolesas will introduce our guest speaker today, Dilek Kurban. Thank you.
Hi, everybody. Hi, Derek, and thank you, as always. And thank you to all the team. It is my super great pleasure today to introduce Dilek Kurban. Dilek is a Max Weber postdoctoral fellow at the European University Institute, where she's now, yes, in Florence. She holds a PhD from Maastricht University Law Faculty, a JD from Columbia Law School, also a Master in International Affairs from Columbia University. Her dissertation that ended up being the book that we're going to discuss today about the limits of supranational justice got mentions, and her book got prizes as well. Before transitioning to academia, she was very involved in think tanks and in policymaking in the wind of democratization in Turkey, in TESEV. I want to say something about her work. Her work is the intersection of legal doctrine, scholarship, legal mobilization, human rights, political science between authoritarianism and democracy, and geopolitics with the highest degree of humanity. This book is a result, is an issue that was with you, Dilek, forever, I know for a fact, and you gathered several titles on the way, you know, to make it happen. The multidisciplinary perspective shows in breadth and depth the complexity of your work, and also an indisputable and extremely detailedly documented and argued case, which speaks about your commitment, your passion, your sharpness, but also about the great efforts that discriminated groups have to engage in to be visible and believed. It is my pleasure to have you here, Dilek Kurban.
But thank you very much, Mara, Dr. Kolesas, for this. Well, first of all, for inviting me to this platform to allow me to share my work with you. And of course, I'd like to thank Derek and everybody else in the team who's made this possible and who's there in the background to make it happen. And Mara, thank you very much for this introduction. It's very moving and flattering. Thank you.
I hope I can do supranational justice to your book, which is so long and so textured that I'm going to try. But I would like you first to ask you to tell the story about the book. You like, you know, the context. You work a lot in your book about the importance of the context and of telling stories. So I would like you to go into, you know, what the book is about briefly, and to tell the story of how this book came about, both in your personal story and also academically in terms of the gaps that you were addressing.
Mm-hmm. Well, so I mean, it's, you know, I tell this actually in the preface of the book, and I felt the need to say that because I think it does give indeed a certain context to who I am, where I, you know, come from, and what this book is all about. So, you know, in 1998 in the summer, I was a master's student at Columbia, as you said, you know, human rights student, and I spent several weeks in Turkey's Kurdish region with assisting a fact-finding delegation from the United States, from Fordham Law School. So I was helping American lawyers and law students and professors in their interviews. I was a translator, interviews with Kurdish human rights lawyers. It was my first time in Diyarbakir, which is the really unofficial, in a way, capital of Turkey's Kurdish region. It was not my first time in the Kurdish region because, and that's the personal element to it. I am Kurdish, but I was born and raised in Istanbul, and I had never lived in the emergency region, although we would visit my grandfather in the summer, so I had some exposure to it. And I had impressions, you know, as a child. But it was also the first time that I met Kurdish human rights lawyers. And, you know, that really turned out to be a very turning point in my life, really, in so many ways. I just was extremely, extremely impressed by the resilience and the courage of this small group of lawyers, men and women, who were in their early 30s, and they were contesting they were basically challenged the Turkish government before the European Court of Human Rights in Strasbourg for the state violence that the Turkish authorities were committing in the region against Kurdish civilians. And when I say gross state violence, I'm talking about gross and systematic human rights violations. And in Turkish context, it was basically four kinds of violations: torture, enforced disappearances, extrajudicial executions, and forced displacement. So it's really, and another thing that I also noticed was, I was translating their conversation, so they would not have been, the two sides would not have been able to talk without me and other fellow translators, but they're also speaking a certain language that I did not really have a command of, and that was the language of law. So I left the Kurdish region that summer with the decision to study law, because I realized that you do actually need to be a lawyer if you want to be a human rights advocate. I want to be a human rights advocate at the time. My intention was to stay in the US and to be a human rights advocate. So I did. I ended up going to law school in Columbia, and I studied law. And then also, initially I wanted to litigate at the ECHR. That's the European Court of Human Rights. I will keep saying ECHR. But I ended up not doing that, but I ended up writing this book. So, after I completed my studies in the US, I actually moved back to Turkey, as you mentioned, Mara, earlier, to be part of this democratization process. And I spent nearly a decade engaging in policy-oriented research, a bit of advocacy, policy, and sort of bridging the global and the international and the national and the local. But I was also doing my own academic research in a way on the side. And my focus was, I started with conflict-induced displacement, forced displacement of Kurdish civilians. And then I spent, over these sort of 8 years, really, I kept going back. I went back and back and back. I was, frequently there in the Kurdish region. And I built lasting relationships, friendships, collegial relationships with the lawyers I met in '98, but also new ones, some of whom are now my very good friends. And, conducted interviews, field work, but also collaborated with them, with the bar associations in the region. We did events together, we wrote reports together, etc. And then, I moved to Berlin for personal reason primarily, but it's also because of the collapse of the democratization, what we thought to be the democratization process in 2012. And that really gave me the chance to take a distance and to finally start writing the story that I've been carrying with me since '98. And as you said, I added I realized I needed one more title, the PhD, just, for the academic job market here. And so this story that I had turned out into a PhD, and then this book.
Now that's wonderful. And you mentioned 2012, and your book covers 1998 to 2012, and then the aftermath. But before going to why that period, I would like you to ask for the audience if you can retrace. I mean, you go at length in your book about retracing and placing, the Kurdish conflict that starts, needless to say, before that, and what are the kind of characteristics of that, both in terms of the acts, the actors, and I'm missing something, and the victims. Yeah, sorry.
No, yeah. Yeah, well, I mean, the book really has two parts. There's the first part has background chapters, because I felt, my approach is what's called law in context. It's, law always operates in a context, right? In a political context, social context. And I think it's very, very important to convey to the reader the particular domestic or whatever context that this particular law is operating. So I have these background chapters, which where I provide a brief, sort of overview of Turkey's democratization process, the evolution of its relations with Europe, with the Council of Europe, with the European Union, the recurrent coups d'etats in Turkey, human rights, minority protection, etc. And in another chapter, I talk about the history of Turkey's Kurdish conflict. where it's, and starting from late Ottoman era. So this is not new. This is not a new, and that's part one. And then part two is really the empirical core of the chapter, which is then based on my own research, which we can get back to later. But so the Kurdish conflict, to go back to your question, it is of course a very old, it's over a century old conflict, started in Ottoman Empire. But what I'm looking at is the most sort of the conflict, the most recent phase, the latest phase of the conflict in a way, which and it was not always the Kurdish conflict. There was this tension, there were problems between the Kurds and the state, Ottoman and the Republic, but it wasn't always in the context of an armed conflict. In fact, actually, the Kurds, especially starting from the 1950s in Turkey, engaged with, there was a political resistance, but it was non-violent, it was peaceful, it was democratic. So they really, demanded, and the demands were very simple. For example, decriminalization of the Kurdish language, things so basic, so simple. But then in 1984, this whole process I explained in the book, I'm not going to go into detail, but the whole, conflict, particularly because of the reaction, the harsh and disproportionate reaction of the Turkish state, in the end, culminated in civil war. In 1984, the PKK, that's the Kurdish acronym of Kurdistan People's Party, which is an armed guerrilla group, basically declared war. They attacked the Turkish military. So since then, we have a war in Turkey, in the Kurdish region. And the date so my book looks at 1987 to 2012, and these dates are indeed important. So 87 is important because that's when three things happened in that year, in the same year. One is Turkey, the government declared state of emergency in the Kurdish region in the name of counterterrorism, which granted the civilian and military authorities in the region extraordinary powers, really extraordinary powers, which then enabled and facilitated state violence, really. And the second thing was the Turkish government recognized the European Court of Human Rights individual petition mechanism. Back in the day, it's no longer the case, but back in the day, when the court was created, when the European human rights regime was created, because there was no consensus among the founding states, in the end, the decision was, it was left to the states, which have ratified the European Convention on Human Rights, to decide whether or not they would allow their citizens, individuals, to go to Strasbourg to individually file a petition, just like they would go to a domestic court. Turkey was the last one to do that. And they did that, the government did it as late as 1987. Today it's mandatory. States don't have that choice. If they ratify the convention, they have to give that right to their citizen. So why did the government do this, right? And at the same time, when they also declared an emergency, which resulted in systematic and gross human rights violations. And that the reason of that is the third development, which is that the Turkish government made a formal application for EU membership. So, and I explained this in the book also in the background chapter, that was nothing new in terms of instrumentalization of human rights in Turkey's foreign policy. Human rights for the Turkish government has always been, also for the Ottoman Empire, by the way, and a foreign policy issue, right? They sort of, they paid lip service to it in order to warm up relations with Europe, and in this case, the European Union. So that's the first date, and 2012 is again under EU pressure, also under the context of the European Court of Human Rights relationships. The Turkish government granted its citizens this time the right to file an individual petition with the Constitutional Court, Turkey's Constitutional Court. We did not have, Turkish citizens did not have right that until then, until 2012. And really, if you want, we can discuss why this was done. But so basically, after 2012, that's basically added.
you froze a little bit at the end with the date of 2012, and I gathered that you were saying that, you know, this granting of citizens to resort to the Constitutional Court in Turkey, what it did was like a lip service remedial instance that preventing, you know, Kurds to go straight to Strasbourg, right?
Not preventing, because anyway, you cannot go straight, because the court, the European Court of Human Rights, and actually the supranational human rights courts, international law in generally, but supranational human rights courts operate based on the principle of subsidiarity, and basically the notion that, you know, individuals should file their petitions only after they exhaust domestic remedies. The exhaustion of domestic remedies, meaning you first have to try your chances in your own courts, and then after you exhaust these remedies, then you go to ECHR. In 2012, what happened was that, so before you had the lower courts and the appeal courts in Turkey, but not the Constitutional Court, because we didn't, you know, individuals didn't have the right to do that. But then in 2012, another layer, a third layer in a way, was added, which basically delayed, in a way, lengthened the process even further.
Mm-hmm. That leads me to ask you a question. You mentioned kind of like four, they're not the only four, right? Human rights violation, torture, forced disappearances, extrajudicial killings, and displacement. And during, you know, this time where all these, you know, Kurdish lawyers presented the cases to the European Court of Human Rights, there was no recognition of systematic state violence, right? And that's the core of the book. And one of the questions, if I understand correctly, is for you, why this happened, right? Why did this happen? And further, you say, why is Turkey a footnote in the literature where the court has failed immensely, right, in recognizing the human rights of the Kurds? Would you speak, you know, to that? Why is that the case? How the court reacted? Why is Turkey, a footnote, and why it shouldn't be?
Mm-hmm. Yes, sure, absolutely. Let me start from the second question, because so basically, you know, when I started really doing new research for this, you know, PhD, and when I started with a story, and then of course because this was going to be an academic thesis, and then I started, of course, looking at the academic scholarship, you know, to see what has been written, and I really was very surprised by what I saw in scholarship on the European Court of Human Rights, also on supranational human rights courts more broadly, but particularly ECHR. So the narrative, which is really widespread, this is really unquestioned, accepted. The narrative was, so ECHR has been a very effective court, actually the world's most effective human rights court. And then until the accession of post-communist countries, right? After the Cold War, you know, the Eastern and Central European countries acceded to the convention, and then they, you know, accepted the jurisdiction of the court, which caused an exponential increase in the court's case law, which is true, of course, you know, which then caused the docket crisis. But and then, you know, and it's also, you know, it's the same in democratic transition scholarship too, as it pertains to Europe. So the story is like this. So there's a dichotomy, right? There were old member states, and then there were new member states. Old member states were established democracies, Western European, with strong rule of law traditions, human rights protection, effective judicial review, which of course, once in a while, needed guidance from the ECHR, but nothing structural, right? The human rights violations there were just sort of marginal in a way. And then you have the newcomers, post-communist, which were new democracies, which did not have rule of law traditions, which really needed structural guidance from the ECHR. Now, and then there's Turkey, no? And Turkey doesn't fit in any of the groups because, of course, it's not post-communist, but it's also not a new member at all. I mean, Turkey ratified the European Convention on Human Rights in 1954. And is actually, and this is a very lesser known fact, is actually one of the handful countries which drafted the convention. Turkey was among the few countries which was around the table who, you know, drafted the convention. So its relations Okay, it accepted the individual petition mechanism in 1987, but it was part of the system. Certainly interstate mechanism was always available, meaning other member states could have challenged Turkey in Strasbourg before the ECHR. And yet you have, state violence, but you also have recurrent coup d'etats. I mean, Turkey had coup d'etats in 1960, 71, 80, systematic human rights violations, not just in the Kurdish region. So I was really, really puzzled. And when you look at the scholarship, and this is literal, either they did not mention Turkey at all, or literally in a footnote or parentheses. And so that was, the part of it. And then what I'm, arguing in the book is that, and then I started to, of course, look at the jurisprudence of the court. So maybe just to say a little bit about my method, just very briefly, I do, sorry.
No, if I may say something that I want to make sure that this state violence goes with military governments and civil governments as well.
Yeah, exactly.
I wanted to clarify that because you talk about the coup d'etat, but there is continuity regardless of the coup d'etat.
Oh yes,
in this.
Absolutely. Absolutely. And thank you, Amara, for pointing that out. In fact, actually, when you look at state violence in the period that I'm looking at, it was civilian governments, because the military staged the last coup d'etat we had, the successful one, was in 1980. There was a military regime for 3 years, 1983, and then they were out. They left themselves under EU pressure. So it was just civilian. Exactly. But that comes, maybe I'll get back to that, the notion of democracy, what the ECHR understands from democracy. But maybe to come back to your first question, how the ECHR did not say that this was systematic, that there was a policy. So, the Kurds, the Kurdish lawyers, basically, what they were arguing before the court was this. Torture, enforced disappearances, extrajudicial executions, and forced displacement, these are not individual phenomena. There is a policy, a state policy organized with the participation of all government actors, the military, the government, courts, of course, judges, prosecutors, which was, that was put in place in the Kurdish region in the name of, under the disguise of counterterrorism. But really, at its core, it aimed at crushing, really, the entire Kurdish population, the civilian population. And that, it was not justified. It was certainly not justified under counterterrorism. So they kept going back to Strasbourg, 10 cases, 50 cases, 100 cases. There were hundreds of cases that were filed in Strasbourg, and they were really identical cases. I mean, names change a little bit. And, in one of the chapters, I talk about the victims and acts and actors of state violence. So I show the modus operandi, in a way, how this has, worked. And so the name changed, facts changed, but they were very, very similar cases. And maybe just I'll make a footnote here, just for the audience here who would be familiar more with the inter-American context. What was happening in Turkey at the time in we call this the 1990s, was no different from what happened in the Southern Cone in Latin America during military dictatorships. And those happened during, of course, military dictatorships of authoritarian regimes, but, civilians picked up on the street in broad daylight, sort of innocent civilians, activists, lawyers, peasants, whatnot, and pushed into, cars without license plates or false license plates, and then disappeared. And then that was it. And then there was denial, right? Families would go to the police. Police would say, no, we didn't do it. Prosecutors would not open investigations. In rare cases where they did, courts would issue lack of jurisdiction, etc. So this was very much like what was happening in, in Argentina, in Uruguay, etc. at the time. But there's also similarity in a way with the Central American conflicts, because this was happening, unlike in the Southern Cone, in the context of an armed conflict, where an entire group of people were targeted because of their ethnicity, like the indigenous communities, in Central America. So what they were saying, I'll just wrap it up here, Mara, I'm sorry, I'm gonna, answer your question fully. So what the Kurds were saying to the ECHR was two things. This is a state policy. This is not individual. and it's discriminatory. This is being done to us because we're Kurdish. And both of these arguments failed in Strasbourg, and they did not have to. The court had its tools, in its authority to actually say, even on the basis of one case, that there was a state violence. But the ECHR just did not want to say that. That's why I say that it was not effective.
Yes, I mean, there's so much to unpack there because you have a whole theory of effectiveness, but let me retrace a little bit and say, you know, why the Inter-American Court, even though I was going to ask you, you know, this question later, but since you brought it up, I mean, why the Inter-American Court ruled, right, that this was a systematic state policy, and why the European Court of Human Rights, you know, didn't. And this goes to the first dimension of effectiveness that you develop, you know, in the book. There was way more leeway that the European Court of Human Rights could have had. And the second part of the question is, why didn't do it with Turkey, right? Why, like,
Mara,
geopolitics?
Mara, sorry, I have very unstable connection. It's Italy, terrible. I did not hear anything after you said the second part of the question. I got your first question, but not the second one.
Let's go to the first.
We'll
take, yes.
Okay, so, you know, okay, please take everyone, what I'm going to say about the Inter-American system, maybe with a grain of salt a little bit, because the conclusion, you know, I raise questions at the end of the book based on my sort of very limited reading of the Inter-American system, although now in my current research project at the EUI, that's what I'm looking at. I'm doing a comparative. And then maybe I should also say a couple of things now. I mean, so in the Inter-American system, so the first case, the Inter-American Court of Human Rights' first judgment ever is called Velázquez-Rodriguez versus Honduras. And that was an enforced disappearance case. And the scenario was very similar. No, somebody disappeared and then not accounted for, denial of authorities, etc. In that, but there's of course a background to it, because that case in the Inter-American Court of Human Rights, unlike in the European courts, individuals cannot go directly. You have to go through, you go to the commission, and if the commission brings the case, Inter-American Commission on Human Rights brings the case to the Inter-American Court of Human Rights, then your case is heard. The Inter-American Commission on Human Rights had already worked on Honduran cases for a long time. And in the context of the Inter-American system, the commission has to be given a lot of, the old commission has to be given a lot of credit. And they were doing all of this. And, I mean, the Honduras, the Velázquez-Rodriguez judgment is 1989, after transition to democracy, no? But the commission's initial work happened during the dictatorships, right? So the commission really was very, very active. The commission members went to Honduras. They tried to, you know, collect evidence themselves. They heard lots of victim testimonies. And then they came up with this theory, which then the Inter-American Court of Human Rights accepted. Let me just leave it there and then talk briefly about what that theory is. So in a situation where the government completely denies any responsibility, but also denies the disappearance itself, and there's no body, you know, we don't even know whether the person died or not, simply disappeared, right? And the families, the victim's family, the applicants cannot really present much evidence because the evidence is totally under the exclusive control of the authorities. In such a scenario, said the Inter-American Court of Human Rights, I'm going to accept circumstantial evidence because applicants cannot give me direct evidence. I cannot expect this from them. Circumstantial evidence, meaning testimonies, not just victims' testimony, families' testimonies, but other witnesses, reports of international human rights organizations, reports of international bodies, media reports, etc. And the Inter-American Court, with the, of course, help of the Commission, looked at this totality, in a way, sort of took a step back and said, what do I see here? You know, this is not an only case, and of course there were other cases. And the court said there's a state policy here of disappearance in Honduras during a specific time. And the court said this, the Inter-American Court, in the first judgment, but only on one judgment. The European Court still does not say it after hundreds of identical judgments. The court could have done it, the European Court of Human Rights. It's because, you know, it insists on direct evidence. It has a very rigid standard of proof called beyond reasonable doubt. It just, although it can do it, and as to why it doesn't do it, I mean, I have, my theories about it, but I think, and that goes back to democracy, I think part of the reason, it's not all, but part of the reason lies in this founding myth, the narrative that the Council of Europe, which the ECHR is a part of, was established by liberal democracies, and that all the members are democracies. So that's one difference with the Inter-American. I think the Inter-American case, my sense is that the judges and the commissioners were very aware of the political context because they themselves also had personal experiences. Particularly in the Southern Cone. No, I mean, you didn't have to explain much to an Argentinian judge about what was going on in Honduras. I think in the European context, they just did not want to accept that a European country was doing these kind of things. The second reason is counterterrorism, and I think that's just the civil war, basically, the armed conflict. That I think was a big disadvantage for the victims because the government said, well, this is counterterrorism, unfortunate things happened to the extent that they accepted things, violations occurred. Well, too bad, things like this happen. And the ECHR really gave was very differential to the Turkish government, which of course is not unique to Turkey in that sense. They were also differential to for example, the UK during the Northern Ireland conflict. There are other reasons too, but basically, and that's why, coming back to your question about effectiveness, what I'm arguing is that when we talk about effectiveness vis-a-vis authoritarian regimes, I have to emphasize this. I'm not talking about liberal democracies. I'm talking about authoritarian regimes such as Turkey. What I'm arguing is that we have to understand effectiveness in a different way. It's not effectiveness, supranational courts are not effective when governments comply with their decisions because authoritarian regimes, well, they don't really change their policies. They paid compensation, but keep doing the same thing. I think they're effective when two things. One, when they do their best in a way, when they exhaust everything in their power, use all their jurisprudential tools and resources like the Inter-American Court has done. And two, and that's the bottom-up dimension, be open to victims and their lawyers and provide them a platform that they're denied at home because in authoritarian regimes, what enables state violence is of course also judicial complicity. And in Turkey, the courts have from the beginning and today too, have been complicit with authoritarian policies and practices.
Well, that's a great answer, and you jump ahead a lot of questions that I wanted to ask. But before going to legal mobilization, I mean, the sense, I mean, you see the need, right, in your book to explain Turkey, like why Turkey is a footnote. It's not a footnote because your argument is the case of Turkey, it actually illuminates issues of wider importance. And the issues of wider importance are, as you just mentioned, first, supranational justice should be differentiated vis-a-vis, authoritarian regimes, and democracies, right, that we cannot take. There's a denial, there's a myth of Turkey as a democracy, and that's related probably to geostrategic reasons that I would like you to expand upon, but also because it is not, we need to take not only procedural and evidentiary, but also legal mobilization. So I want to talk about that, later, and in particular, if you draw the connections with the US, right? Because if I understand correctly, the scholarship, the literature about that starts here with African Americans. Mm-hmm. So there are two different parts of the question that go directly to the very textured answer that you gave.
Yeah, would you like me to talk about legal mobilization, Mara? Or
first, however the order that you want. If you want to start with legal mobilization. Yeah,
and the geostrategic.
Either.
Or and the geostrategic, right? Okay, thank you. So let me just also say one more thing. My main focus is state violence, as I said, but I also discuss the Kurds' cultural and political rights claims because they also made these claims before the ECHR, and these are also domains where there has been a historical continuity in state practices. banning, criminalizing the use of Kurdish language, not allowing Kurds to effectively use their democratic rights. How? By, for example, closing one political party after another. And the ECHR, every time finding a violation, there are 7, 8 judgments like that. But again, the ECHR never saying that there's a policy of political party dissolutions. So I'm also talking about that. And that goes to the special political rights, goes to the democracy issue, right? So let me talk about maybe legal mobilization first. So as Mara said, it's a fairly recent literature, started really, basically scholars, and that's why it's so bottom up, and I like it very much, because scholarship really started with an observation of an inspiration from a social phenomena and a political phenomena, and that's the civil rights movement, right? So citizens acted first, African Americans, they mobilized against segregation. And doing that, as we know, right, Brown versus Board of Education and many others, they used the law to contest discriminatory laws and to seek political change, never under the illusion that law is always just and equal, or courts are always impartial, but still pushing it. So it started in the US, later slowly started coming to Europe. And also to supranational courts. So there's also, research on how women's movements, environmental groups, disability groups have mobilized the European Court of Justice, the European Court of Human Rights to contest discriminatory policies. Now, that scholarship also, although of course that's a fairly new, relatively speaking, new scholarship, but again, there's a gap there too, because it mainly is about liberal democracies, contesting, mobilization against liberal democracies, changing slowly. There's work on legal mobilization, for example, of LGBT movements against Singapore, so an authoritarian context. There's also some work on, for example, Colombia, legal mobilization of displaced women, for example, in before Colombian Constitutional Court. But we still don't lack first enough studies, but also a theory. The theory doesn't explain the hurdles of trying to mobilize law and courts against authoritarian regimes, particularly in the context of armed conflict, violence. It's the combination of these two that makes the Turkish case also interesting for that scholarship as well. Because Singapore is authoritarian, but there's no armed conflict there. There's no sort of violence, state violence. And in Colombia, you have state violence, but it's a democratic country. So in Turkey, what you have is an authoritarian regime which is engaged in gross human rights violations, and the kind of hurdles that lawyers then face in such contexts are just completely different. Because in the US, what kind of hurdles are we talking about? Resources, of course, you need to raise money. Yes, of course. Obviously, now, for example, we see how you also have to select the courts carefully. Some courts are more favorable to the government. Certainly in the segregation South, that was a challenge. Not to, diminish that at all, but still, by and large, even during the segregation, even in the South, all of this was happening in a country that was, in general, a democracy and, based on rule of law, with, of course, big deviations. But here, what was happening was these lawyers that I mentioned, and in fact, actually, for example, one of them, it's in the cover of my book, that I met back in 1998, who then became a great friend and colleague, was killed in 2015. We lost him, and the cover of the book is from his funeral. So, these lawyers, and when I met him, he had just been released with several others from incommunicado detention, where he was tortured and threatened with death. And in the end, they did kill him. So that's the kind of hurdles. They get killed, they get tortured, and then there are other hurdles. Evidentiary issues. How can you prove the state disappeared your son when or your client when there's no evidence of even the detention? So that's the kind of that's the legal mobilization part of it. And there too, I'm saying that we need a new theory, but for that theory, we need more empirical research, kind of the research that I did, so that all of this empirical researches on different contexts feeds into a theory on law in authoritarian context of violence. And concerning geostrategic reasons, yes, I mean, and just as a footnote, one difference that I see, for example, between Turkey and Latin America, Southern Cone, for example, you could say perhaps that, Argentinian civil rights movement had the fortune eventually of Argentina losing its geostrategic importance during the Cold War. At some point, it became not so important. Turkey was always very important for the West. I see, Mara, that maybe you don't, agree, but
there's so
when
much
you
to
look
qualify
at
there, but I'll take the argument for the sake of Turkey. Yes,
yeah.
Yes.
But basically, what I'm trying to say, and of course, here there's the U.S. too. No, we need to talk about not just.
No, because we lost you.
Okay, so during the Cold War, Turkey's proximity to Russia, after the fall of the Berlin Wall, and the Islamic Revolution in Iran, and then the Soviet invasion of Afghanistan, etc. Turkey's proximity to the countries which were governed by political Islam, or where political Islam was rising. Today, migrant crisis. Again, Turkey is such an important, and I think one reason, and I don't say that very strongly, but I think just in the underlying reason, sort of in the political background, was also this. And you see this a lot also when you look at how EU talks about Turkey, for example, that it is an important ally. In the end, and I think I don't say this explicitly in Turkey in the book, but I think there is, in a way, a sense, and the way I read it is, I think for the European Court of Human Rights judges, but also for EU officials and politicians, in a way, there's a sense that, this is good enough for Turkey, in a way, no? The kind of standards that they would expect from the French government in its treatment of its own citizens are different, and they are different, and we see that, So in that sense, geostrategy has always been a curse, in a way, for the people in Turkey.
It happens also in the margins of the world, and with this I'm not justifying, right? But Turkey has more geopolitical importance and economic interest and security interest than what seems to be the worth of the life of Kurds, and back to 1915, Armenians as well, that went absolutely unrecognized. So when you talk about the limits of supranational justice, and we can also talk about the limits of national justice, for example, in the US, drawing an analogy, there are groups that are more superfluous than others,
yeah,
right?
Sure.
And this is an implicit argument that goes throughout the book, because, what becomes crucial is not only this differentiation between, democracy and authoritarianism and state violence, but also about minorities or targeted groups, if we don't want to talk about minorities, because minorities depends on the number. I mean, I don't like the term, but that's not the point. It's like a stigmatized, right, oppressed group.
Exactly. And that's the dilemma, no? Because even in democracies, minorities, let's say vulnerable groups, are also numerically a minority. Going back to Turkey, the Kurds will never, ever have the political power through, representative democracy to come to government and to change these laws. They just will not. As Eyal Ben-Venisti puts it beautifully, these minorities are at the behest of majorities, right? So that's why we have courts. That's why we have judicial review, precisely because there's something structural in the representative democracies that can enable governments to, systematically discriminate against minorities or certain groups, certainly, in the US as well. So then the question is, and then when you have this issue, minorities, but in an authoritarian context where there is a civil war and there is state violence, what role is there for supranational courts? And that's why I frame, my question in a way where it's a limited. It's a particular question, because I say, what are the possibilities and effective limitations of effective supranational judicial review of authoritarian regimes which are engaged in state violence against minorities, because this is where they're needed most. That's where they matter the most. And that's why, going back to what you said earlier, Mara, also, that's also why you cannot footnote Turkey in a way, because it is, in the European context, it is the hard case. Because it looks like a democracy, it was been a nominal democracy, it has representative institutions, regular elections, etc. And yet, you have these gross human rights violations against a particular group. And as we speak, I mean, we didn't talk about that, but I mentioned political rights. As we speak today, dozens of elected Kurdish representatives, I'm talking about members of the parliament, mayors who were elected, are in jail. And this is also not new. This has happened all the time. And the ECHR took 2, 3, 4 years to even hear their cases. So there's this, if this was happening elsewhere, just imagine, I mean, of course, it happened in Spain a little bit, that was also interesting. But just imagine, that you have, and this is systematic, this keeps happening. So, the government, basically the Kurds are not allowed. This is disenfranchisement, basically, right? They don't have, effectively, they don't have voting rights, and they don't have political representation rights. That means this is not a democracy, right? But the problem is that the ECHR treats this as a democracy, and the moment it does it, then it becomes impossible, really, for it to be effective.
So you pose that as a dilemma. You also quote, Larry Diamond, that we're going to have here on January 6th, talking about the crisis of democracy, when he talks about elections without democracy, because Turkey has, in fact, elections, but all of the democratic guarantees are not there, minorities' rights, human rights, free press, etc., etc. The issue is how can a court such as the European Court of Human Rights or any court, even a national court in a democracy that treats citizens differently, be effective? And by effective, I don't mean your level of effectiveness, your definition, but effective in actually defending the human rights, right, of those individuals and or groups.
Yeah, no, absolutely. And that's a very fair and good and important question, obviously. And therefore, I mean, so we should not, and I certainly don't, expect a magic formula from courts. They're not equipped to do that, nor should they. I mean, many of these issues actually can only be resolved politically in a democratic, in sort of like the democratic operations of the government, etc. So what do we mean by effectiveness? So what can the European Court of Human Rights do, or what can courts do in general, as you said? So what I'm arguing is do their best, first of all, right? Do your best, meaning if there's a state policy, you have to say there's a state policy. If there's discrimination, you have to say that Turkey has violated Article 14 of the Convention, which concerns discrimination. If the evidence is not clear, if the facts are not established, then do fact-finding trials and hearings, which the court used to do. Send your delegation to Turkey and do that yourself. If the Turkish courts are not doing it, then you do it yourself. Do not issue admissibility decisions so quickly and so easily, which the ECHR also does. Do not assume, and this is the most important part of it, the principle of subsidiarity I mentioned earlier. It's a core pillar of the ECHR system, meaning that the European Court of Human Rights role is only subsidiary to that of the national judiciaries, right? But that is based on the assumption that the national judiciaries are doing their job, right? They are engaged in judicial review. Now, when they don't do that, as in the case of Turkey, then do not apply the subsidiarity principle. Do not expect applicants to exhaust domestic remedies, because domestic remedies don't exist, they're not effective, right? And remain open, be open. Don't force applicants to settle their claims with the Turkish government or with governments. All of this is what the ECHR has been doing. Now, what would have happened had the court done all of these issues correctly? Now, first of all, I should say that the reason why I talk about the EU process in my book, and as you know, it's always in the background, is because that there was a golden opportunity when the EU process was at its height. When the Turkish Erdogan, when he first came to power, he was engaged in these reforms. There was an opportunity for the ECHR to make a difference. The court did not use this opportunity. So the golden opportunity in a way is missed. But still, even today, even for Erdogan, at his worst time, these authoritarian regimes still care about their international reputations. They still care about being named and shamed, right? They don't want to be the worst offenders. So that's one thing. And from a victim's perspective, and this is something that the court, unlike the Inter-American Court of Human Rights, forgets systematically. It's not a victim-focused court. It isn't. From a victim's perspective, even if torture doesn't end, even if the body of his son is not found, for the Strasbourg court, the European court, to say that Turkey has engaged in systematic violence, in itself, the judgment itself, even without compensation, is a remedy, is a reparation. It's important because they feel vindicated, because they feel, okay, somebody is believing in me, right? But what the ECHR is doing, and more so, especially after the entry into force of the constitutional complaint mechanism, the ECHR basically has reversed the roles and effectively rubber stamping the Turkish Constitutional Court and rejecting the cases. And I should also note, in the ECHR system in general, only around 5% of all the applications the cases that go to Strasbourg end up in a judgment. Around 91% are issued inadmissible, including cases concerning gross human rights violations. So you have a court which basically has turned into a bureaucratic machinery in a way, whose main drive is to diminish its docket crisis, docket basically, to get rid of cases as much as it can. So when you're preoccupied like that, then you become prone to authoritarian tactics like the Turkish government of creating new remedies so that the court says, okay, you deal with this.
Wow, that's such a big, and great answer. I have 2 comments to that. One is, just highlight what you just said, that it lost its mission for its own kind of institutional perpetuity, right? Like the permanence as an institution in the most, not efficient, but less burdened way. That's one point. But the other is, how can I frame it? The other is, like you said, this judgment would constitute a formal reparation, right? A symbolic reparation in the form of, recognition of a crime committed. But you know better than I do that has very serious practical consequences if that is ruled, particularly with a state like Turkey, right? That tends to pressure or threaten when things like that happen. So how would that ruling kind of be possible?
Yeah, that's also a very good question, Mara. And I get that question sometimes. And I have a couple of answers to that. The first is, well, we don't know, no? Because that has never been tried. Appeasement has been the strategy always, no? Oh, let's not forget Turkey. Let's not make it too angry. So we don't know. Secondly, unlike, say, Russia, which is a completely different animal in a way, which is independent and strong, has its gas, is a big power, can actually, be on its own. Turkey is financially, politically dependent on Europe. It's the power dynamics there is the other way around. It's Turkey that needs Europe, not the other way around. And for Turkey, still, even for Erdogan, the Republican project of Westernization and Europeanization is important. Turkey takes pride in the fact that it is one of the first members of the Council of Europe. It's been there from the beginning, also for NATO, also for OSCE, etc. And there is a mechanism actually in the Council of Europe to suspend memberships. They can suspend the memberships of member states. In the history of the entire organization, this was used only once, triggered only once, against Greece, when it was governed by a junta, the military junta. And they were going to suspend Greece, they were going to kick Greece out. And then when the generals saw that this was happening, they left themselves, but they were going to do that. No? And how did that happen? The Greek junta, they came to power, and then they declared a state of emergency in the, in the entire country under the pretext of anti-communism.
Okay, Dilek froze. I know that the connection sometimes, in Italy is not the best. It's very spotty. I cannot fill in for her argument because she has all the knowledge. But I will take this moment to encourage you to ask questions via chat. Yes, I am telling her that she froze. So I want to encourage everyone to ask questions via the chat. I know this issue seems to be really particular to the European case and to Turkey and the Kurdish conflict, but there are a lot of parallels and analogies that can be drawn, not only with the US case, but with cases that we have already discussed, right? Dilek, are you here? I apologize for this. Dilek.
I apologize, it's on my part, sorry. We live in a 15th century villa in Florence, and it's just, the internet is terrible.
Now we don't feel bad for you at all, like we all envy you.
Shall I take from where I left? I don't know where you guys
please do.
The junta, no?
Yes.
I mean, I talk about this because it's important. Please allow me to, sort of give a bit of detail. But, so the military comes to power. They topple the democratically elected government in Greece, and then they declare a nationwide emergency.
Okay.
In the pretext of.
Dilek, if you can turn off your video, maybe you have better reception. Okay, let's try that. I apologize, everybody.
And then they were going, and then in the end, Greece left. Okay, yeah, me too. Sorry. So in the Kurdish context, the Kurdish region was governed by emergency rule for 15 years. 15 years. No emergency regime can last that long because under law, international human rights law, emergencies are supposed to be provisional. But the ECHR has never asked this question. They've never asked, really, Turkey to justify this. They never sent their own delegation to find this out. So that's what I mean. They really never really fully pushed Turkey in a way to and hold it really accountable. So, and again, it's because, they acted because unlike in Greece, Turkey was not governed by the military. Coming back to what you said earlier, Mara, and I think this is important, this sort of assumption that it is Turkey is governed by liberal democracy. So again, to come back to your question, that I know where I started because of course I lost my train of thought. If the suspension mechanism would be triggered, I really do not think that Turkey would have say, well, okay, that's fine, I'm going to leave. They wouldn't do that. They cannot do that because Turkey is dependent on Europe. And also, even if it does, maybe let's try that. No, I mean, it's just this is something that has never been done, and state violence continues, gross violations continues, and Turkey is now in a place which is even much worse, of course, as we know, since the start of this failed coup attempt, which I also talk in the end.
Yeah, and this point, Dilek, goes to actually one of the dimensions that you point to, effectiveness, right? That you pointed before, and that is exhausting. I mean, the European Court of Human Rights have not exhausted everything, that it could have done, including beyond the procedural and expanding, to circumstantial evidence, etc., also considering suspending kind of Turkey, putting pressure and acknowledging that, it's not a democracy, even though it's a civil government, because here there's a conceptual conflation as well, right? If it's military, it's authoritarian. If it's civil, it's democracy, but that is not really the case. Right.
I should make something clear, though, is that The suspension mechanism is a political process. It's not up to the European Court of Human Rights to do that. It's up to member states and the governments of the Council of Europe to do that. So it's a political process, and there's no political will to do that, basically. But even the ECHI itself did not indeed exactly exhaust its remedies. I mean, just think that as we speak, the third largest political party in Turkey's parliament, the third one, and the second largest opposition, is basically dozens of its deputies, Kurdish deputies, have been stripped of their immunity, parliamentary immunity. They've been stripped of their seats. Many are in jail, others in exile. And this is happening in a supposedly democratic country. And the ECHR, it took the European Court of Human Rights to even issue a judgment. It took it for over 3 years to do that. I mean, just think about the kind of message that this sends, you know? That parliamentarians are, by the way, they are sitting in jail without conviction. I should also say pre-trial detention. This is pre-trial detention.
And I want to give everyone a chance to ask questions, which they're feeling very shy to ask. So if no one is asking a question, what I want to say is this is not only the authoritarian traits of the Turkish government are not only even though strongly so against, Kurds, but also, freedom of speech, many academics who spoke, about the authoritarian, policies of Turkey. So this is not only concentrated on the Kurdish region in terms of, the authoritarian traits of the Turkish government.
Yes, legal repression, political persecution is not, certainly. That's, and as I said, I'm looking at state violence, which is gross human rights violations, but I'm also looking at legal repression of the Kurds. And this letter, as you said, Mara, certainly is not limited to the Kurds. Historically also, although in terms of its scope, breadth, frequency, etc., it has always been disproportionately targeted against the Kurds. But having said that, yes, indeed, after the failed coup, especially Erdogan regime went, even before the coup, they went fully after civil society, especially academics who raised their voices, objected to state violence in the Kurdish region. And after the failed coup, this time against allegedly Gülenists, sort of individuals who are allegedly associated with this cleric called Fethullah Gülen, who Erdogan blames responsible for the coup attempt. So what happened and what's continuing to happen is that actually for the first time in Turkey's history, we have a very wide group of victims who are targeted for state violence, legal repression. But again, state violence continues in the Kurdish region only, except there have been a few, 3-4 that we know of enforced disappearance cases against alleged Gülenists as well. But other than that, and also torture, of course, after the failed coup. But in terms of, I start the book with the story of this one woman, 57-year-old Taybetinam, who was killed by the Turkish military in front of her home when she was coming from a visit to the neighbor, and her death, there was war, basically urban warfare, and there were curfews. No one was allowed to go out of home, and she just went across the street to her neighbor, and her body lay on the street for 7 days. Her family watched her, first of all, bleed to death, and then they were not allowed to remove her body. When they did, her husband was also injured, etc. This kind of thing happens in the Kurdish region, this kind of, utter disregard of human life, of human worth, of human integrity, making someone's, dead body stay on the street for 7 days and not allowing the family to pick it up, and then not allowing the family to be present, etc. And of course, extrajudicial executions, just, executing, doctors and lawyers, whatnot, just for speaking up. So that's something particular. And that has to do, of course, with the historical dynamics of the conflict, as I said. But yes, of course, what's going on, as I said, it's now, pretty much everybody who's dissenting with Erdogan is in danger now. And, people are, there are just so many in exiles and prisons and etc. And it's really, it's very tragic. Also, what has happened to, by the way, individuals who are alleged to be Gülenists, most of whom anyway are not, but what does it mean even? Anyway, that's another story, but yes, of course, exactly. But again, it's still different.
So, I mean, I want to kind of like round up, if we don't have questions, what two issues. One is, we go back to the importance of, of Turkey geopolitical, not only vis-a-vis the European Union, but also the US, right? In terms of strategic reason and why there is no international pressure, sanctions or any form of pressure, that's point number one. And when that's the case, the ones who pay the price, are oppressed groups, right? That's always the case, and Turkey is not alone, in those groups of countries. The other thing is just more conceptual, as like your book illuminates issues of wider importance, and even though we have discussed the specificities of Kurds and the Turkish state and the European Court of Human Rights, there are core lessons, right, or path of research that, the amazing multi-layer book you've written open up. So I would like you to point to that, in academic terms, in empirical terms, in practical terms, political terms. What are the venues that the kind of work that you have done open up?
Thank you, Mara, for these, again, great questions. I've been on, sanctions and of course, US is the key, because now we're at this, when I wrote the book, relevant to the EU process was relevant for the Turkish government.
Dilek, I apologize, everyone, for this.
It sounds like she's trying to come on.
I'm so sorry about this, Derek and everyone. There are the high cost of living in a Florentine villa, I guess.
I see that, Mike.
If anyone has a question, I would encourage you to ask the question.
Marlene, I see your question.
Yes, she needs to be unmuted, she's telling me.
Okay, there we go.
Are you there?
Okay, I'm very sorry, everyone. It's just so frustrating for all of us. Do you hear me, Mara?
Yes.
Yes.
Okay, great. So let me just try to be brief then. On sanctions by the US, I think that's, that's very important, not just for US, but also for the European Union, because regimes like Turkey, Putin is, a bit similar to, quite similar actually. These leaders like Erdogan and Orban and Putin, they do not value and take seriously language of diplomacy or politics or democracy. And every time the EU or the US, especially EU, talks about shared values or importance of democracy, etc., it signals to Erdogan that he thinks that they are weak, that they are at his mercy. What really needs to be done is to show, strength and firmness, and he will back down because he has to. Turkey is in financial crisis, its economy is very weak, it's completely dependent, especially on the US, but also on Europe. Again, it's not like Russia. And in terms of, and I saw actually a question from an audience. I also would like to, Dorothy, answer that in this respect. She asked whether, they should travel to Turkey. Of course, it is, obviously your own decision. But, when I'm asked, I always ask people, not an advice, of course, but not to. Partly because, especially because tourism is a very important source of revenue for the government. And, it's just, we, unfortunately, they will only, it seems like, a little bit of change may only come with economic decline in a way. So I actually in favor of a global sanctions regime and movement against Turkey, not just against Turkey, of course. And then Mara, to your question, you hear me again? Okay, because I don't see your face. In terms of new areas of research, but also, I mean, lessons for courts and scholars. I mean, I think the main thing that I'm saying is that we have to have in scholarship, but also in the practice, of course, a differentiated approach. Democracies, liberal democracies, and authoritarian regimes need to be treated differently. They raise different issues. So this has all kinds of implications, but it's just, I mean, for the practice of the courts, again, for the European Court of Human Rights, for example, as I said, you know, they should not apply the principle of subsidiarity. They should not expect victims to exhaust domestic remedies, which are not anyway there anymore. You know, they should not grant a wide margin to the Turkish government, etc., etc. And for scholarship, you know, this differentiation is also important there, because authoritarian regimes, particularly in context of violence, raise different challenges for theory development, for conceptualization, etc. So I urge for a bit of more humility in a way in theoretical scholarships, and I think they also need to theories have to be really fed with and based on, reflect on empirical data that are collected from different contexts, etc. You know, and you know, my main critique for much of theoretical scholarship is indeed that they kind of I don't think that they do their work enough. You know, they need to, I think, read more, and of course more research needs to be done. That's also true, no, in domestic context. But main argument is basically that we need to have a differentiated approach to democracies and to authoritarian regimes.
That's an excellent point. Differentiation between authoritarian and democratic regimes, and this doesn't go hand in hand with military and civil. You can have authoritarian traits in alleged or not fully, as you like to call them, you know, brown countries, which are, you know, democracies that have areas that are non-democratic at all, in the words of Guillermo Donen. Dilek, to finish up, since, you know, the connection is spotty, I would like you to say a little bit more about what you're working on now and what you expect to produce, so we can look forward to it.
Thank you, Mara. Well, I mean, okay, so I'm trying to do something a bit ambitious. So it's I'm in the beginning of this research project, and I actually need to raise funds for this. I need to find grants to be able to really do it. But basically, so because I concluded that the ECHR did not exhaust its resources and power, and that the Inter-American Court of Human Rights, I believe, did a better job in addressing state violence. You know, the question I'm addressing is, you know, to what extent the ECHR's ineffectiveness has had to do with limitations that are inherent to supranational judicial review, or just judicial review, which goes back to your earlier question, Mara. To what extent because it's a court, or to what extent it was a product of its unwillingness to do that. So I'm looking at the two regimes from a comparative perspective, so the Inter-American regime and the European human rights regime. And what I'm looking at is not authoritarian regimes, and I'm realizing this more and more, because in the Inter-American context, that distinction doesn't apply so much in terms of comparing, because, you know, much of case law concerning state violence in the Southern Cone, you know, the judgments were made after transition to democracy. And you also have state violence in democratic countries now, etc. So, but what I'm looking, therefore, is I'm looking at gross human rights violations, also against particular groups such as indigenous communities, and looking at how the Inter-American Court and the Commission of Human Rights have been dealing with these issues, evidentiary issues, burden of proof, standard of proof, admissibility, scope of the rights, you know, which reparations, of course, is big in the Inter-American system. So what I'm hoping to do, what I'm aiming to do really, is to this time develop a theory on effectiveness, not just you know, empirical research, sort of like theoretically oriented empirical research, but to do a theory myself, to put forth a theory myself. So that's the very ambitious goal. We'll see how much progress I'll make in this.
I'm sure you will. I'm sure you will. And I look forward to it, to include the legal mobilization, you know, the sociological and political aspects in how the law work or doesn't work. We're gonna have on December 8th, the International Day of Human Rights, Luis Moreno Campo, who's the first chief prosecutor of the Hague International Criminal Court. And we're going to continue discussing the possibilities and the limits of justice, which whose lessons we can, you know, take internationally, regionally, but also nationally, right?
Mhm.
So Dilek, thank you so much for an incredibly illuminating conversation. I encourage everyone to read the book that you cannot see, but it's called The Limits of Supranational Justice. You will enjoy it greatly. It's a very dense and incredibly informative and sharp book. Dilek, do you want to say anything in closing?
Yes, well, thank you. I would like to thank the audience very much. I'm really sorry for this terrible internet connection. It's just, you know, normally I would have done it from the office, but it's, you know, 11:20 p.m. now here, so I couldn't. Thank you very much, Derek. Thank you, Derek and Dawa, for your support, technical support, and Mara, wholehearted thank you for having me here and for your encouragement and kind words about my work.
Dilek, it's been a pleasure. I encourage everyone to sign up for the discussion session at 3 p.m. Pacific time, and I hope to see you there. Thank you so much. Thank you, everyone.
Bye.
Thank you, Dilek. Thank you, Mara.
Bye.
Thank you, everyone, for joining us, including my dad, Harvey Lehner. Take care,
Oh.
everyone.
Oh, hi, Derek's dad.
Hi, Derek's dad. Yes.
Okay. See you all at the discussion group. Bye-bye.
Okay.